live on YouTube. Ready to go on? Okay. We're on the record in case number 9739 in the matter of the application of Chaberton Solar Orchard Hill, LLC, for a certificate of public convenience and necessity to construct a 3.24 megawatt solar photovoltaic generating facility in Queen Anne's County, Maryland. Start with appearances, starting with the applicant.
Good afternoon, Your Honor. My name is Andy Flavin with the law firm Troutman Pepper on behalf of the applicant, Chaberton Solar Orchard Hill, LLC.
Good afternoon.
Good afternoon, Your Honor. Steve Tolson, Assistant Attorney General, Counsel to the Power Plant Research Program within the Department of Natural Resources.
Good afternoon, Your Honor. Isaac Lindenbaum on behalf of the Office of People's Counsel.
Good afternoon. And staff?
Good afternoon, Your Honor. Jennifer Purvis, Assistant Staff Counsel, appearing on behalf of staff.
I received exhibit lists in advance. Thank you for that. Did you, Mr. Flavin, want to go through and mark Chaberton's exhibits?
Yes, please, Your Honor. And may we please have marked as Exhibit 1 the revised certificates of publication for the pre-hearing conference, which is 12 pages, filed on July 17th, 2024, under mail log number 310885.
So marked.
Thank you. May we please have marked as applicant Exhibit 2 the cover letter and certificate of service for the application, which was filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 3 the petition filed on May 10th, 2024, also under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 4 the application appendix filed on May 10th, 2024, also under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 5 the ERD narrative, also filed on May 10th, 2024, under mail log number 309578.
So marked.
May we please have marked as applicant Exhibit 6 ERD Appendix A, which is the conceptual site plan, filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 7 ERD Appendix B, which is a soils report, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 8 ERD Appendix C, which is the geotechnical report, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 9 ERD Appendix D, which is the United States Fish and Wildlife Service correspondence, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 10 the ERD Appendix E, which is the Maryland Department of Natural Resources correspondence, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 11 ERD Appendix F, which is Maryland Historic Trust correspondence, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 12 ERD Appendix G, which is the Aquatic Resource Investigation, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 13 ERD Appendix H, which are the interconnection study materials, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 14 ERD Appendix I, which is the original glare analysis, filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 15 ERD Appendix J, which is the FEMA firm map, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 16 ERD Appendix K, which is the Forest Conservation Plan and Forest Stand Delineation, filed on May 10th, 2024, also under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 17, ERD Appendix L, which was the Phase 1 Environmental Site Assessment, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 18, ERD Appendix M, which is correspondence with Queen Anne's County, also filed May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 19, ERD Appendix N, which is a vegetation management plan, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 20, ERD Appendix O, which is the EJ screen report, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 21, ERD Appendix P, which is the Avert emissions tool, filed on May 10th, 2024, also under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 22, ERD Appendix Q, which is the Alta survey, also filed on May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 23, the updated ERD Appendix R, which is the JEDI report. That was filed on May 16th, 2024, under mail log number 309578, and that was filed under public and confidential versions.
Okay, I don't think that was mail log 309578.
Oh, no, I apologize, Your Honor. I have the wrong number down here.
It's 309705.
Thank you, Your Honor.
It'll be marked as applicant Exhibit 23.
Thank you. Next, Your Honor, may we please have marked as applicant Exhibit 24, ERD Appendix S, which is the water use exemption application, also filed May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 25, ERD Appendix T, which is the subscriber organization letter order, also filed May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 26, ERD Appendix U, which is the PV cyst report analysis, also filed May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 27, ERD Appendix V, which is the Maryland Department of Environment Tier 2 Anti-Degradation Review Letter, also filed May 10th, 2024, under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 28, the verification of Michael J. Doniger, filed May 10th, 2024, also under mail log number 309578.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 29, the responses to the PPRP's Data Request 1, which was filed on June 18th, 2024, under mail log number 310319.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 30, the direct testimony of Ryan Boswell, which was filed on September 9th, 2024, under mail log number 312161.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 31, the direct testimony of Andrew Reese, which was filed on September 9th, 2024, also under mail log number 312161.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 32, the certificates of publication for the virtual public hearing, which was filed on September 16th, 2024, under mail log number 312335.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 33, the revised conceptual site plan, filed on October 14th, 2024, under mail log number 312863.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 34, the certificates of publication for the second public comment hearing, filed on January 6, 2025, under mail log number 314667.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 35, the sign affidavit for the second public hearing, filed on January 9th, 2025, under mail log number 314733.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 36, the settlement status update, filed on January 13th, 2025, under mail log number 314842.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 37, the supplemental testimony of Ryan Boswell, filed on January 24th, 2025, under mail log number 315136.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 38, the updated decommissioning plan, filed on January 24th, 2025, under mail log number 315136.
So marked.
Thank you, Your Honor. And lastly, would Your Honor prefer to enter the Chaberton's responses to bench data request 1 as a bench exhibit? Or would it be better to enter that as applicant Exhibit 39?
Well, first of all, we're only marking right now. It can be marked as applicant exhibit 39.
Understood, Your Honor, thank you.
So, Chaberton Solar Orchard Hill LLC's responses to bench request number 1 will be marked as exhibit 39.
Thank you, Your Honor.
Is that it?
Yes, Your Honor, that's it.
Okay. Does any party have any objections to any of the exhibits?
No objections.
I have a question about exhibit 2. Do you have that in front of you, Mr. Flavin?
Just one moment, please. Sorry. I'm opening the document right now. And, Your Honor, Exhibit 2, I just want to confirm this is the cover letter and certificate of service.
The certificate of service in particular.
Okay, Your Honor, I have it open.
You signed this certificate of service, correct?
Yes, Your Honor.
And it was filed on May 10th of 2024, correct?
Yes, Your Honor.
So on May 10th of 2024, how did you know that on May 13th of 2024, copies of the application for a CPCN would be sent to the below agencies?
Because, Your Honor, that's the date that we scheduled with our internal document production and mailroom service to send those packages out
At your law
via
firm?
FedEx. Yes, ma'am, at the law firm.
Are you able to provide a certificate that they were in fact sent on the 13th?
Yes, Your Honor, I believe they were, I can provide, if you would prefer that they were sent on the 13th or that they were, provide delivery confirmation.
However you want to certify that they were actually sent, because I've never seen a certificate of service that reads this way.
I apologize, Your Honor, just to explain the reason.
That's okay, you don't need to explain.
Okay.
In order for a CPCN to perhaps be issued, I need a certificate that they were actually sent.
Yes, Your Honor, I'll be happy to file that.
So for what it's worth, that can be entered. So applicant exhibits 1 through 36 will be entered into the record. Do you want to call Mr. Boswell to the stand?
Yes. At this point, the applicant calls Ryan Boswell.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name for the record, and give us a business address.
My name is Ryan Boswell, RyanBoswell. Business address is 1700 Rockville Pike, Suite 305, Rockville, Maryland.
Mr. Flavin, can you voir dire the witness, please?
Excuse me?
Can you voir dire the witness, please?
I apologize. What?
I need his qualifications
Oh,
and how his testimony was prepared.
okay. Certainly, Your Honor. Good afternoon, Mr. Boswell. Could you please state your background, please?
Yes, I'm Vice President of Development with Chaberton Energy. Have a background in chemistry, and I've been a solar developer for 6 years.
Thank you. And are you familiar with the testimony that you submitted in this case?
I am.
Was that prepared by you or under your supervision?
I prepared that, yes.
Okay. And if I were to ask you substantially the same questions here today, would you provide the same or substantially similar answers?
Yes.
Thank you.
Do you have your supplemental testimony in front of you?
I do, Your Honor.
Okay. On the first page, it's not numbered, but the first page, line 11, you state that the applicant has made several updates to the plan, which was defined. It's the decommissioning plan. You didn't submit a red line, right?
No, Your Honor, we did not submit the red line.
At the bottom, starting on line 21, you state, furthermore, the plan outlines the conditions under which decommissioning may occur, including natural disasters, the end of the project's useful life, a period of at least 12 months without electricity production or any other reason determined by the project owner. In this case, don't you have a lease expiration date?
Yes, Your Honor. Our base lease is valid for 20 years.
With options to renew,
Yes,
but limited options to renew, right?
that's right.
So wouldn't another condition under which decommissioning would occur would be the end of the lease term?
Yeah, yes, Your Honor. If the lease was not renewed after those extensions or a new lease was signed, that could be cause for decommissioning, yes.
So you're saying that you believe that the lease doesn't have a finite, although it has a finite term, it could be renewed beyond the 40 years?
I do believe, Your Honor, that a new lease could be established at the end of the 40-year period after all extensions had been exercised.
And that new lease would not affect the CPCN in any way? In other words, you wouldn't have to, the project owner wouldn't need to come in and get a new CPCN because they're operating on under a different lease? Is that your position?
I have not considered that issue, Your Honor. I think that at the end of 40 years, the array is likely to be not operating at a commercially optimal capacity. And so, yes, I think it's reasonable that the project would need to seek another CPCN or a subsequent project on the same property.
Has Chaberton sold this particular project?
No, Your Honor.
But it intends to sell the project, correct?
Yes.
Would that be before construction?
Typically, it is our that is our normal business case that we sell the project just prior to construction.
Do you know the method by which Chaberton typically sells the project? Is it a transfer of, so we're talking about Chaberton Energy Holdings. Does Chaberton Energy Holdings transfer the individual Chaberton Solar Orchard Hill LLC, which is then renamed?
That's correct, Your Honor. I can't speak to whether or not it's renamed. Typically, the entire LLC is transferred so that the obligations that the project company signs carry with it through the transaction.
Including decommissioning, correct?
That's correct, Your Honor.
Starting on page 2 of your supplemental testimony, you start talking about, in addition to pricing related to PV module recycling and salvage, But who prepared the cost estimate?
The entirety of is the question who prepared the entirety of the decommissioning cost estimate?
Yes.
That was prepared in partnership with ARM Group.
So you worked on it.
Yes.
And then, starting on line 11, you state the applicant would like to explain the methodology for how it arrived at the salvage value and recycling costs for PV modules. And then you start talking about based on the experience of the service provider, approximately 70% of the PV modules can be salvaged at the end normal operations of a solar PV plant. Are you taking that from what you attached to the updated decommissioning plan?
Yes, Your Honor, that's information provided by Ontility.
Is that on page 5 of attachment B to exhibit 38?
Your Honor, I believe it's positioned as a hypothetical here on page 5, but in communications by email with Ontility, they confirm that that is their experience based on the projects they've previously decommissioned.
It is posed as a hypothetical. In fact, it says, in theory, there could be a 70-30 split, 70% being usable. And you have some prices here. Do you have any idea what year they're talking about here with these prices?
Those prices are their current day pricing.
So, and likely, well, I took from the top where it says it has to be updated every 5 years, that, I mean, there's a lot you have to read into this limited thing, but that perhaps they're talking about 5-year-old panels. Would you read it that way?
I think it's reasonable to interpret it that way, correct.
But you say that 70% of the PV modules can be salvaged at the normal normal operations. So normal operations is more like 20 to 30 years, right?
That's correct.
So you believe that 70% of the PV modules can be salvaged after 20 or 30 years?
That is based on the feedback from Ontility and communications by email.
That we don't have in the record, and we don't have a witness, correct?
That is correct, Your Honor. Someone from ARM Group may be able to speak to that, but we did not provide those communications in the record.
Do you have your response to bench data request number 1 in front of you?
I do, Your Honor.
Second page, question 1-8. Your response states, as explained in detail below, Queen Anne's County Ordinance, as amended through November 26, 2024, defined as the code, does not apply to the project, as the code makes no provisions for community solar energy generating systems, CSEGS, under Maryland Code Public Utilities 7-306.2. Accordingly, any CPCN granted to the applicant in this case will supersede the code for purposes of the project. That was your statement, correct?
That's correct.
So I'm trying to understand what you're saying here. Does that mean that a CPCN granted in this case would supersede the site development review process in Queen Anne's County?
What I mean to say, Your Honor, is that the code was not written for community solar. The code was designed for utility scale solar. In the definition of Queen Anne's County Code, It explains their view on utility scale solar, which includes generating electricity at wholesale or retail price for sale to a utility. And community solar does not sell the electricity to a utility.
You state any CPCN granted to the applicant in this case will supersede the code for purposes of the project. Does that mean that a CPCN, if it were to be granted in this case, would supersede the site development review process in Queen Anne's County?
I mean to say that siting regulations are the purview of the Public Service Commission for projects of this size, but we are willing to comply with site development review at Queen Anne's County, with the exception of some of the provisions that were laid out in my supplemental testimony. In particular, Queen Anne's County Code says that utility scale solar or any commercial solar above residential size is a conditional use and lays out the provisions for plan submittals as a conditional use. But we feel that provision in particular does not apply to the project.
Yeah, on page 3 of your response, you say, additionally, if the code were found to be applicable to the project, then the applicant specifically requests that the commission exempt the project from the following portions of Chapter 18:1 of the code. When and what forum would the code be found to be applicable or inapplicable to the project?
It's my assumption that it's at Your Honor's discretion to decide whether the code is applicable. We tried to respond to that question in a way that we can adhere to the reasonable requirements of Queen Anne's County Code without being hamstrung by the strict language of the law requiring a conditional use hearing and Board of Zoning Appeals hearing. But for most of the design requirements, we are happy to comply.
Mr. Flavin, turn to you for a second. Exhibit 36 is the settlement status update,
Yes.
in which you stated Chaberton reviewed and will not contest the proposed licensing conditions filed by the Power Plant Research Program on December 20, 2024, under mail log number 314419.
Yes.
So Chaberton accepted the recommended licensing conditions filed by PPRP, correct?
Yes, Your Honor.
So, Mr. Boswell, are you familiar with the licensing conditions?
I am, Your Honor.
Okay. Do you have those in front of you?
Yes, I do.
So condition 5 that PPRP proposed and Chaberton agreed to states it's entitled Final Site Plan Submittal, but it states prior to the start of construction, Chaberton Solar Orchard Hill shall obtain site plan approval from Queen Anne's County, which incorporates the approvals of various site development plans administered by the county. I'm trying to understand whether you are saying that Chaberton intends to comply with this license condition or it doesn't have to.
Your Honor, we would like to and intend to comply with that condition. My supplemental testimony, the intent there is simply to point out that in the construct of the code, because commercial solar is a conditional use, there is not a clear pathway by which we would be granted a site plan review.
And this might become a discussion I have with your attorney, but you just said you'd like to comply. But what do you think is requiring Chaberton to comply with something that it doesn't think applies? 5 talks about a soil erosion and sediment control plan, a stormwater management plan, an exterior lighting plan, and a grading plan. I believe those are all in Queen Anne's County's code, correct? Which you say don't apply. So I'm trying to understand, you've agreed to this condition, but you're telling me that you're not going to comply with this condition because you don't have to, because Queen Anne's County code doesn't apply.
I understand the confusion. I apologize that my supplemental testimony was not worded more clearly. We will comply with those provisions of Queen Anne's County Code. It's specifically the regulations or the provisions laid out in Chapter 18 in the land use. It's, I think, 195 S that covers solar facilities. Those are the provisions that I've spelled out in my supplemental testimony, for which we have some objections to the strict letter of the code.
Yeah, I have it in front of me, S, solar arrays. And I understand your argument about why you don't think it applies. You understand that Queen Anne's County takes a different position, correct?
Yes, we do.
Okay. But S, solar arrays, 3, submission requirements. I understand it's asking for conditional use approval that you don't think you need to get. But in A1, it's site plan level information with engineered construction drawings, including grading. 3, stormwater management plan. 4, exterior lighting standards. These are the same things that PPRP is saying that you're going to have to come back with. And these are the same things you're saying we don't have to comply with. So, like I said, this might become a discussion with your attorney, but I don't understand whether you're saying you're going to comply with these conditions or not. Sounds like to me you're saying a CPCN could be issued with conditions that you've agreed to, but you can't comply with those conditions, so you're not going to.
May I respond, Your Honor?
Yes.
Thank you. No, I think the purpose of that, Your Honor, obviously, as we've discussed, Chaberton noted its position that it didn't believe that the way the definition of utility scale solar array is provided in the Queen Anne County Code, it would apply here. However, I think Chaberton certainly acknowledges that the Commission has the ultimate citing authority, and certainly could direct Chaberton through a CPCN to comply with even conditions in the Queen Anne's County Code that Chaberton believes under the code currently do not apply to it, but the Commission certainly could require Chaberton to do so. And Chaberton was attempting to point out certain provisions in that, I guess, 18.1 that it was concerned about, and requesting the Commission's permission to not enforce those particular requirements.
When were you requesting the Commission's permission to not enforce those provisions?
In response to the bench data request.
That's your preferred method of asking the Commission for something?
No, Your Honor, it's not. It was something. It was a question that again we responded to at that point.
I'm going to need you, to the extent you'd like this Commission to do anything, to put it in a motion and spell out exactly what you think you'd like the Commission to do.
Understood, Your Honor.
Okay, I'm not going to do it because you think maybe a CPCN supersedes whatever you think it supersedes. Because tell me exactly what's going to happen after a CPCN is issued with regard to licensing condition 5 that you've agreed to. Do you have it in front of you?
I don't have the licensing
Okay,
conditions
it's
in
the
mind.
final site plan submittal, which requires Chaberton Solar Orchard Hill to obtain site plan approval from Queen Anne's County.
Yes.
So just the process, after a CPCN, what you envision would happen?
Then Chaberton would go and seek site plan approval if, as directed by the Commission, but it was specific. There's certain provisions in there that it was particularly concerned with.
Right, but
And
what
as
would
part of
happen?
that
What would
approval.
happen?
We would go to Queen Anne's County and ask for the site approval, or approval of the site plan, putting forth Chaberton's project as approved by the Commission. And if the site plan was not approved by Queen Anne's County because it took a different interpretation, then Chaberton would come back to the commission.
Which part of a CPCN order do you think approves a site plan?
Wouldn't say it approved a site plan, but a site plan based on the project as approved by the commission.
Okay. You and I are going to have a little bit of a different interpretation of what a CPCN order does in this case, because typical CPCN orders approve applications to construct, and they are limited by the conditions attached thereto, which PPRP usually proposes, and that includes things like site plan approval. So it's not my interpretation that a CPCN order from the commission approves a site plan or the project as incorporated into a site plan. It gives you permission to construct pursuant to the conditions that have been incorporated into the CPCN. So I'll reiterate that if there's something you're asking this commission to supersede, you need to make that clear in writing and request the appropriate relief.
Understood, Your Honor. Thank you.
Back to license condition 5, I didn't actually understand the wording of it. I'd like to know what does it mean? Prior to the start of construction, Chaberton Solar Orchard Hill shall obtain site plan approval from Queen Anne's County, which incorporates the approvals of various site development plans administered by the county. This final site plan, comma, to the extent not inconsistent with the revised conceptual plan filed in the docket on October 14, 2024, shall contain but is not limited to the following. What do you think is required then if I don't know, what does that mean? The final site plan, to the extent not inconsistent with revised plan, shall contain these things. Do you know?
I'm sorry, I didn't hear the question clearly.
So prior to the start of construction, the condition that PPRP proposed would require you to obtain final site plan approval. The final site plan, to the extent not inconsistent with the revised conceptual site plan, so to the extent consistent with, shall contain the erosion sediment control, stormwater management, exterior lighting, grading. What does that mean to you?
For those areas of our site plan, those details of our site plan which conflict with the Queen Anne's County Code, for example, not giving a specific example, but if Queen Anne's County required a deeper vegetative buffer, for example, we would like the conceptual site plan to prevail as the design.
Okay. So the final site plan only has to contain those things if it's consistent with the, wait a minute. As long as the final site plan is as good as the revised conceptual site plan, it doesn't have to contain these things?
That's not what I intended to say there. It's specific to the design details laid out in Queen Anne's County Code, Chapter 18, 195S. One specific example we show
Wait. Are you looking at revised or recommended licensing condition 5?
Yes.
That's all I'm talking about.
Yes.
It doesn't talk about Queen Anne's County, other than to say you have to get site plan approval. So this final site plan that you get approval of from Queen Anne's County, to the extent not inconsistent with the revised conceptual site plan. What does that mean?
What I mean to say there is, to the extent that the Queen Anne's County approval of final site plan does not conflict with what is the conceptual site plan submitted in this case, then we would comply with other provisions of their code, the details as it speaks to in 5A5, all necessary project details. We will comply with the stormwater, the erosion sediment control, road requirements, exterior lighting plan, the grading plan. What we are seeking,
If, so long as it's consistent with the conceptual plan. I mean, that's what it says.
yeah, that is poorly worded. We were trying to make a caveat for a requirement in the code, such as an opaque fence, that is not a detailed, a design detail which is shown on our conceptual site plan.
Do you have the decommissioning, updated decommissioning plan in front of you, Exhibit 38?
I have it with me.
Did you draft this?
I reviewed it. I did not draft it de novo.
So starting at the top of page 1, introduction, Chaberton Solar Orchard Hill project or project owner is how you want to define Chaberton Solar Orchard Hill?
Yes, Your Honor. As I mentioned earlier, the obligations transfer with the project company. When
Oh, I understand that, but why would you define the company as the project? Isn't the project, and the project owner is the project owner? Why are you defining Chaberton as a project?
That should say Chaberton Solar Orchard Hill.
Right, and then in parentheses it says project or project owner, as if later on, whenever you use the term project, you were referring to Chaberton Solar Orchard Hill?
The project company is called Chaberton Solar Orchard Hill, LLC. The solar project is Chaberton Solar Orchard Hill. And so, yes, we've referred to them interchangeably.
That doesn't really work. You have 29 inverters planned on page, not numbered, but 2.
That's correct, Your Honor.
As I've learned from you in a prior case, they last about 15 years. Is that correct?
That's correct.
And you replace them on an as-needed basis.
That's correct, Your Honor.
On the 3rd page, Section 5, decommissioning process, 2nd paragraph, decommissioning consists of, do you need to get there? Sorry.
I'm trying to find the decommissioning plan, but go ahead.
I'll wait till you have it.
Okay, I have it, Your Honor.
Okay, 3rd page. Section 5, decommissioning process, 2nd paragraph. Decommissioning consists of the removal of the above and below ground facility components, management of excess wastes and materials, and the restoration of ground surface irregularities. What does that mean?
Your Honor, that means backblading for filling in any holes left after we remove the
You're restoring ground surface irregularities.
restoring irregularities to a smooth condition.
Okay, and then in this decommissioning plan, in the following, starting the following paragraph, you've just basically restated Queen Anne County's code sections having to do with decommissioning, right?
Yes, largely that's true.
Okay. And you said you did help prepare the cost estimate?
Yes, Your Honor.
Sorry, back to your Exhibit 39, your responses to BDR 1. On page 4, the last bullet, and then the second item, 18:1-95S5E7. As long as that the CPCN require a certification from applicant that the lease agreement between the applicant and the property owner specifies legal responsibility for any environmental pollution that occurs after the solar array is removed. What are you attempting to do there?
What I mean to communicate there is that we have a lease in place which obligates us to be responsible for any environmental pollution. And when we review the Queen Anne's County Code, it appears to place that responsibility on the property owner. We would like to be clear that that is the project company's responsibility.
Okay. Any redirect?
No, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, so Chaberton applicant Exhibit 39 will come into the record. 37 will also come into the record, although I have to tell you that towards the end, it's not going to get a lot of weight. And applicant Exhibit 38, the updated decommissioning plan, will come in, but not Exhibit B, because there's no witness to support it. No foundation's been laid. And Exhibit A also won't come in because there's not a witness to support this. I don't know who Charles Walker is. He hasn't provided testimony in this case. All right, PPRP. you have a witness?
Good afternoon, Your Honor. PPRP has 8 exhibits that we would like to have marked for identification. We provided a list, and I do apologize. It says Worcester County. It should be Queen Anne's County. Everything else is correct there. PPRP exhibits 1 through 7 were all filed on December 20th, 2024, all of them under mail log number 314419. So PPRP Exhibit 1 for ID is the direct testimony of Sean Seaman. PPRP Exhibit 2 for ID is the Department of Natural Resources, Maryland Department of the Environment Secretarial Recommendation Letter. PPRP Exhibit 3 for ID is the initial recommended license conditions. PPRP Exhibit 4 is the project assessment report. PPRP Exhibit 5 is Appendix A to the project assessment report, which is the applicant's responses to selected PPRP data requests. PPRP Exhibit 6 for identification is Appendix C to the PAR, which is the Environmental Justice EG Screen Report, and that should probably be B. And then PPRP Exhibit 7 is Appendix C to the PAR, which is reference sections of PPRP's website. PPRP Exhibit 8 was filed on January the 30th, 2025 under mail log number 315258, and that is PPRP's response to bench DR1. Like having marked those for identification, we'd like to move for their admission into the record.
All right, they're all marked for identification, but you said that on your list, PPRP Exhibit 6 is actually Appendix B.
Well, I'm just looking at this. We have
We need to
Appendix
look at
A, then it goes C, D. I believe what it was is there's no glare analysis in this one, and that would have been in there. So 6 should be Appendix B, and 7 should be Appendix C. Am I correct on that?
I can look it up. Yeah, A is data
Right.
response.
B is the EJ screen. C is the website. So that's what I said. That's correct.
Okay. Do you want to make any corrections to Mr. Seaman's direct testimony?
No, Your Honor, we do not. I will note that PPRP does intend to file updated recommended licensing conditions after this hearing concludes. We will be adding a site access condition, and the State Highway Administration belatedly asked us to insert 2 more conditions on that. And we hope to file those within the next day or two, but we wanted to wait till this hearing adjourned in case, for example, we need to look at any other RLCs.
You have, go ahead if you want to.
I'm sorry. They just want us to update the contacts. It's not new conditions.
Oh.
Just updating a current condition with new contacts.
Oh, okay. It's just new contacts in an existing condition.
Okay. When you do that, and you send me a courtesy copy, can you send me a Word version?
Word, and we'll do red line and clean, Your Honor.
Okay. And you have, what, 15 days? Is that correct?
Well, it's 15 from when the public hearing was held, but we generally, after the hearing, there have been cases where we've done amended RLCs, so when was the public hearing?
No, that's fine. I don't interpret that way. This is also a hearing open to the public. I think you have 15 days from the evidentiary hearing. That's why I usually ask you to waive it.
It's in 7207D, which deals with the public hearings where the 15 days is mentioned, but I agree, it makes sense to be 15. I mean, because things can come up here at the hearing that require correction to make the record clear.
Okay. Does anybody have any objections to any of PPRP's exhibits?
No, Your Honor.
Okay. I thought, though, in what's been marked as Exhibit 8, Mr. Seaman said his testimony was in error.
In there?
So why don't we have Mr. Seaman come up?
Yeah, he's here.
We'll go ahead and We'll admit 2 through 8 into the record, and then we'll hold on 1.
Would you please state your name, your work address, spelling your name for the record, please?
Yes, my name is Sean Seaman, spelled SHAWNSEAMAN. I work for the Power Plant Research Program within the Maryland Department of Natural Resources. Our address, business address, is the TAWS State Office Building, located at 580 Taylor Avenue, B3, Annapolis, Maryland 21401.
And Mr. Sheeman, was the direct testimony that's been identified as PPRP Exhibit 1 prepared by you or under your supervision?
Yes,
Is it true and accurate to the best of your knowledge?
yes,
Do you, if you were testifying today under oath, would your testimony be the same?
yes.
Do you have any corrections or additions to add to that testimony?
I do. As the hearing examiner pointed out in my direct testimony on page 8, and it's captured in bench DR 1-4, I use language talking about the land use recommended license condition. That was an error. My response to the bench DR addresses that
And corrects it.
and corrects it.
Your Honor, I have no further questions. I'll tender the witness.
Did you swear him in?
No.
Did you swear him in?
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
Yes, I do.
And apply to all that you just said.
I was going to say that, but I didn't.
Thank you.
Yeah, I didn't know how to say it.
Okay. Do you have your response to bench data request 1 in front of you?
Yes, Your Honor.
Okay, 1-3.
Okay.
I'm trying to understand how it's going to go. So I wanted a timeline. So we have a calendar here. PPRP's recommended licensing condition for glare requires that the additional glare analysis be performed and filed in the docket no less than 60 days prior to the start of any construction. So let's say the contractor wanted to start construction on May 1st.
Okay.
So you go back 60 days, and we're not going to count, but we're going to say March 1st,
Okay.
right? So you're saying no later than March 1st, they would have to file in the docket the glare analysis itself.
An updated glare analysis.
Okay.
Yep.
And then what's going to happen with that?
Um,
On March 1st, we have a May 1 construction.
right,
March 1, they file an updated glare.
right. The intent of that is to give the commission and/or PPRP the ability to review that updated glare analysis prior to construction, so that if there's any unacceptable glare, we can, or the applicant can try to mitigate it.
Okay, how would they know that you found there to be unacceptable glare that they needed to mitigate?
We would hope that their glare analysis would identify and address that. But if it were to occur that they missed something that we then caught, I think what's been done in the past is we've gone to an administrative hearing and filed our glare analysis with proposed mitigation options.
Okay, well, you said you would hope they would catch it, but what if they just file an updated glare analysis and it shows a problem on day minus 60? I guess you seem to be anticipating that they wouldn't do that they would mitigate it at the or propose mitigation at the same time, but the condition doesn't require them to do that. It only requires them to file the updated glare analysis on day minus 60, right? Just says shall file the results.
Right.
And then you have, if the results identify that the final panel type, array design, tracking technology, or layout has has materially changed the project's glare profile. Okay. Who is determining whether the results materially changed the project's glare profile?
I believe the applicant would file that, assuming that, so it's not the results, it's the design and layout, and there's some other things in there too, but what we're trying to capture here is that we understand these projects are in conceptual phase. They're often less than 25% design. They almost always or often change before what we call as-built, meaning how the project's constructed. And we're trying to capture those changes to avoid safety issues in the future. So the intent of this is to essentially have a second review of the project that's going to actually be built, not just a conceptual project that's presented in the CPCN process.
Yes, and I want to make sure we have time for it.
Yes.
So it sounds like to me, actually from what you've told me before, almost a guarantee that the final panel type, array design, tracking technology, or layout is going to change the project's glare profile, because it's going to change. But I guess my first issue is that an applicant could have a difference of opinion, perhaps, on whether it was a material change.
Yes, I understand that concern.
Okay, that's my first issue.
Yep.
So, and then if I could get past that issue, they file the updated glare analysis in the docket and propose mitigation to PPRP for review no less than 45 days.
Right.
So that's like mid-April.
Right.
Let's say April 15th. So does that mean that sometime between March 1st, I might have done my dates wrong, but sometime between when they file it in the docket, and they have, basically, PPRP has 15 days to let them know they need to propose mitigation?
So the way this is worded, or at least our intent, maybe it's not clear, is that the applicant would file 60 days in your hypothetical of March 1st, then no less than 45 days prior to that. So 15 days later,
So March 15th.
yeah, let's call that March 15th hypothetically, is when they would give us their proposed mitigation to obviously mitigate the glare.
So you're giving PPRP how many days to let them know they need to file proposed mitigation?
15 days.
Well, they can't learn and do. You know what I mean? They need to file it in 15 days, but how long are you giving them to do it? You're kind of assuming two things happen at the same time.
Yeah. So maybe I'm not understanding you, but
Okay,
yeah,
March
okay.
1st, they file it,
Mhm.
and PPRP looks at it and says, hey, you've got to propose some mitigation.
Yeah.
How many days do you think you would like to have to review it and get to them with, hey, you got to propose some mitigation? Because they need time to actually propose the mitigation, right?
Right. So what we hope is that in your hypothetical that once the final layout and design is set, I won't say approved by the county because of those issues, but once they know their final design, we actually hope that at the 60-day mark, so your hypothetical March 1st, that they give us an updated glare analysis as well as proposed mitigation. The 15 days is to ensure that we have a chance to look at it so that if we do our independent analysis and realize that there's some unacceptable glare that we feel isn't mitigated, that then gives us another 45 days to work that out in the process of administrative hearing. At least that's the intent of that.
So you would be happy if it said, Chaberton Solar Orchard Hill shall file the results of this glare analysis and propose mitigation in the docket no less than 60 days.
Yeah, yeah.
That would work for you?
That would work, yes.
Okay. And then take it out of the next paragraph. PPRP is going to perhaps file something in the docket in that 15 days. Instead of that they're getting the proposed mitigation to you to review, it's actually no less than 45 days, PPRP would file its review of that proposed mitigation, right?
Yeah.
Because you still probably need a few days, to have a hearing.
Right.
Okay.
Your Honor,
Yes.
if I may interject, if it's 60 days before the start of construction, but several years have passed since the order was final, I don't believe they would file it in the case, they would file it in the case jacket, but since that is a final non-appealed order, I believe that the parties would still have to go to the commission and seek permission during an administrative hearing to modify the CPCN, because that order belongs to the commission and it's final. Now, if it was done, obviously very quickly after, before a final order was entered, or if there was an appeal going on, that might be different, but in
Do you have
most,
a case number of an old CPCN? I don't think the cases get closed.
well, no, the case jackets stay up, they don't get closed, but
It's not a modification of the order.
it is, but when those are done,
No, it's not.
It generally goes from the PULJ to the entire commission to be handled during a Wednesday administrative meeting.
If
I
it's a modification.
Modification.
I don't see how this is a modification.
Well, yeah.
So one that I remember is Mason-Dixon Solar. It was the first one where we had this issue. They asked for a 3-year extension, and then we realized that the texture of the glass changed, and we dealt with that at an administrative hearing. I'm not saying that was the right course of action, but that's how that was
Yeah,
done.
I don't have the case number for Mason.
Yeah, I don't have it either in
but
front of me.
It was a while back, too.
Yeah, that was probably 2020. And now, sorry.
It's great. So the rest of C says PPRP will file any revised recommended conditions within 45 days of receipt of any glare analysis. So what are you saying?
I'm just saying that would be done at an administrative meeting. It would not go, to the best of my knowledge, it does not go back before the original PLUJ who
Right.
handled the case. It goes to an administrative meeting of the PSC where the parties file their
Yeah.
recommendations.
So
and-
you're saying that gets you a hearing sooner? How soon did you get on an administrative meeting agenda?
I'm sorry, what?
How soon did you get on an administrative meeting agenda?
Fairly quickly sometimes.
Okay. All right.
A week or two.
But you need to, if you're the developer, you need a decision, right?
Right.
So what if there's some sort of issue? Like you're assuming it's going to go to an AM and the commission's going to go, great. And then they can go construct. But what if there's any kind of
that can't
issue?
be resolved, then it gets delayed. I've seen them delayed for months,
Okay.
longer than that.
So,
And that also allows staff then to prepare their buck sheet and do an analysis, which usually will incorporate the proceedings up until that date and provide a recommendation. as
yeah,
well.
I don't know that 45 days prior to construction to get the proposed mitigation before the commission is too short. You're saying it's, I was trying to make sense of kind of what happened before that.
I don't think we believe it's too short of a time. It's-
Okay.
I just will point out for the it is, we do say no less than, right? And the idea behind that is, hopefully if in your hypothetical, let's just say that they have it done on January 1st, so 3 months ahead of time, we would hope that in order to avoid delays, the applicant would then provide that to us. So just pointing out that, no less doesn't prohibit them from submitting it even a year before then.
Do you have a solution to the materiality issue?
I don't. I don't.
I can offer one. If the original glare analysis said there was no problem and the revised glare analysis says there is, that's a material change.
Well, as Mr. Seaman has pointed out, what he's saying materially changes is not the glare, but the final panel type, array design,
Yeah.
tracking, right?
I am, because that would dictate whether or not a new glare analysis needed to be run. So if the project were built, permitted by the county, let's just assume it gets permitted by the county, and then the final design is the same layout, panel type, buffers, just let's assume everything is the same, then they would not need to do a new glare analysis. But if anything changes, that could be, like I pointed out, that could be as simple as the coating of the panels. And as I pointed out probably in other cases is, a lot of times a couple of years after the CPCNs are issued and they actually go to construction, the panels have been updated from the supply, from the vendor. So it's very unlikely that at least the panel type will be exactly the same. The layout may be the same and things like that, and that's why I'm saying, most, if not all, these projects would have some type of material change.
In your opinion, you see any issue if the word materially is removed from that condition?
No.
So we just read any change.
Any change to final panel
Yeah.
type, array design, tracking technology, or layout?
Yeah, I would not have a problem with that.
So basically, from what you've told me, they're going to do an updated glare analysis
Yes.
that they're going to submit in the docket. PPRP is going to review, let them know if they need to do any mitigation, and then you're only going to come to the commission at an AM if they don't agree to it, right?
Yeah, PPRP would like to do a glare analysis, an independent glare analysis, on the final design rather than conceptual. And we're trying to write conditions that, unless the conceptual, which is unlikely, unless the conceptual is exactly as intended to be constructed, that we get another opportunity to look at an updated glare analysis.
Okay. But unless there's an issue with the glare, there's not going to be a revised recommended condition.
Correct.
So there will be no reason to come to the commission.
Yeah, correct.
Okay. I'm going to try to understand. So in your response to 1-4, is PPRP still recommending that the applicant be required to get site plan approval?
You're referring to condition number 5, I believe?
Yes.
Yes, we are still
So
recommending that.
they don't have to certify that they designed it in substantial compliance. They actually have to get site plan approval.
Need a verbal response.
Oh, yes, sorry.
Okay. So what does the sentence, do you have it in front of you?
I'm sorry, I didn't hear that question.
Do you have it in front of you?
I do, right here, yes.
Okay. So the second sentence in A, this final site plan, to the extent not inconsistent with the revised conceptual site plan filed in the docket on October 14, 2024, shall contain, but is not limited to the following. Do you know what that is trying to do?
Yeah, I listened to the earlier testimony, and the intent of this, I can only explain the intent. The wording is, I understand the word is a little confusing, but the intent of this, again, is we understand that these designs are conceptual at this phase, and will very likely change as they become more final. And what we're trying to say is we're just trying to point out that actually occurs.
So the items that the final site plan shall contain, and you have Romanet 1 through 5, does the final site plan have to contain those regardless of what's changed or hasn't changed from the revised conceptual plan?
Can you say that again? I'm sorry.
The things that the final site plan
Yep.
shall contain, Romanet I, a soil and erosion sediment control plan, Romanet II, a stormwater management plan, Romanet III, an exterior lighter plan, 4, a grading plan, 5, all necessary project details, including but not limited to the final selection of solar panels, and it goes on. Those items need to be in the final site plan that gets approved, regardless of whether it's different from the revised conceptual site plan?
Yes.
So
So-
no matter what happens between the revised conceptual site plan and the final site plan, the final site plan has to include the items you've included in the condition.
Correct. And that's our current understanding of what Queen Anne's County requires. So we're trying to capture their requirements. And of course, the preemption authority was talked about earlier. So we are trying to, understanding that the commission has preemption authority and could, if they choose to do so, grant approval of this project, even though it's outside that overlay area, we're still recommending that the applicant go to the county and get these permits.
Mr. Towson, what's your understanding of the commission's preemption authority? Is it with regard to zoning?
No, it's citing and everything encompassed within citing. It's much more than zoning.
So it's your opinion that the commission can override and say that a developer doesn't need to get a soil and erosion sediment control plan or a stormwater management plan?
The commission has very broad and broadly interpreted authority, but I don't believe it would do so, and PPRP has not made that recommendation. PPRP's job is to submit recommended conditions that are protective of public health, safety, and the environment, and that's what requires them to go to the county and do that. I don't believe that the Supreme Court case that came out of Washington County, Perennial, spoke about, preempting particular requirements, county requirements or whatever. But what it basically said is, at the end of the day, the Public Service Commission determines whether or not a CPCN will be granted. And if they do grant that CPCN, the county may not obstruct or impede the possessor of that CPCN from moving forward by trying to raise their requirements as impediments. And I believe 7207E was amended, in fact, to add things like you don't have to comply with floating zone exceptions or special use things. Clearly, the legislature is siding on the side of an expansive interpretation of the PSC's authority rather than a restrictive one.
So the commission has the authority, but as far as PPRP has recommended in this case, pursuant to license condition 5,
To require those 5 Romanettes, yes. And I would note the commission is required by statute to give due consideration to these factors. So there's no statutory permission to just ignore them. They have to be given due consideration and balanced. And I believe that all of the proposed orders I've seen do exactly that.
but you haven't seen a proposed order which has said that based on the commission's review, no stormwater management plan is needed, right?
I have not, and in fact, I am aware that several counties in the past had said that they would, if a CPCN was granted, they would not participate with the developer. And so legislation was passed, I believe, last year that said you cannot ignore a developer who comes to you with the CPCN and refuse to give them these permits, again, as a means of obstructing or stopping the project from going forward. So again, the General Assembly is aware of what some of the counties have done and has enacted statutes to prevent that and reaffirm commission's authority.
So what does PPRP think is going to happen should a CPCN be issued which requires the developer to obtain site plan approval from Queen Anne's County in this case?
They will go, I believe PPRP's expectation is that they will go to the county and get the requirements of RLC 5. And I believe Mr. Flavin or perhaps Mr. Boswell both said they intend to do so. So it's
That's not quite what I heard. They said they can't get that approval.
I'm sorry, what?
They don't agree. They can't get conditional site approval. They don't agree. They don't think it applies. And in fact, Mr. Seaman, in a bench data request, agreed with them that there's no county regulations.
Well, that was the issue of whether it's a utility scale or whether those regs applied to the commercial or community solar, correct?
Yeah, can I clarify that? Would that help?
Hang on a second. let
Okay,
me get
sure
there.
thing.
You're talking about 1-7?
No, I was looking at 1-4. I thought that's what you mentioned. I'm sorry. Did I? Bench DR 1-4?
Yeah, but if you go to 1-7, explain in detail how the decommissioning license condition directs the applicant and Queen Anne's County to utilize the Queen Anne's County bonding process as described. And that's where you talk about
Right.
the different, you say the purpose of this subsection is to establish guidelines for the siting of a utility scale solar.
Yeah, and I'm just pointing out that it doesn't, because it's a community solar project, it doesn't fall into that utility scale code. Having said that, we do not write our decommissioning plan. We write it on behalf of the state. We don't write it specific to the county. A lot of times we don't even really, there's details in the county that may not be captured in ours, but essentially, we're writing a decommissioning condition that from the state's perspective, if that makes sense.
Okay, if we go back to 1-4, sorry, let's start
Yeah,
there.
sure thing.
You state, as noted in the applicant's ERD and PPRP's PAR, Queen Anne's County's current zoning ordinance does not allow for the construction of community solar projects on agriculturally zoned land outside of the utility scale solar array overlay area. And that's the reason why you did not include a license condition requiring that the applicant make a compliance filing certifying that the project design is in substantial conformity. Correct?
Yes, we didn't believe that condition could be met because of that, because of their code not allowing solar projects outside that overlay area.
Okay, so if you don't think that they can comply with a license condition that would require them to certify that the project is in substantial conformity with site plan requirements, how do you think they're going to comply with license condition 5?
Condition number 5 does not talk about substantial conformity. That's the detail that we're trying to identify.
So there's going to be some process by which they obtain final site plan approval, even though it's not in substantial conformity with the site plan requirements.
I believe so. I'm not an expert on the codes, but I believe, my understanding is because solar projects are not allowed outside that overlay area, the county would not be able to decide that it's in substantial conformity. However, they could still, the applicant could still submit these plans to the county for approval.
And in which case, per your response to 1-8, those code provisions would apply.
Correct, and I got those right from the county. I actually reached out to the county and asked them for these codes because I'm not an expert in individual counties' codes.
Can you repeat what you said about what you think is going to happen if a CPCN were to be granted? You said you think Chaberton and PBRP are in agreement about what's going to happen.
I thought I heard Chaberton say that they intended to comply with the,
Did you review the response to bench data request 1 from
yes.
the company?
Oh, no, from the company? Yeah, I read it.
And you took from that they intend to comply?
No, I'm taking from the testimony here today under oath by Mr. Boswell and the comments made from council's table by Mr. Flavin. He said, we intend to comply. That's what I thought I heard.
What do you think requires them to comply?
RLC 5, which they said they've agreed to. They haven't contested it.
Did you review the updated decommissioning plan?
I have not.
No interest in that?
Oh, no, I didn't say that.
Well, I don't know if I brought the code
So-
section, but PPRP is supposed to provide, oh, I did bring it.
So I know that was filed in late January, and I don't do that myself. That's one of our consultants. So it just, it takes time, and we just didn't have enough time before today to do that.
Okay, so in order to comply with 3-306 of the Natural Resources article, PPRP is sticking with its original condition on decommissioning?
No, I wouldn't say that. I'll have to answer that question after our review. We could modify, hypothetically, we could end up modifying that condition after review.
You're going to modify the conditions, including the decommissioning condition?
I believe so, and I'm trying to think about this. I believe it was the Pine Rock case where Your Honor had questions about the decom plan, and a number of issues came up that PPRP took under consideration and is revising a number of these decom plans to try to be responsive to the concerns that you expressed and to make sure that we have the best decom plan that we can have until it gets reviewed 5 years out.
Yeah, and barring any obvious differences, we're working on updating Pine Rock, and then we intend, if it makes sense, to incorporate that here.
Okay.
And I should have mentioned that earlier when we were explaining some potential changes to our RSCs. I apologize for that.
Any redirect?
No, Your Honor.
Thank you. Thank you.
Thank you.
Down. OPC, no witnesses. Any statement for the record?
No, Your Honor.
Does OPC support the project? I should say, do you support approval of the application for CPCN in this case?
We do not oppose approval of the application in this case.
Staff?
Staff does have one witness to call, Your Honor.
Okay, I don't have any questions for that witness, and I understand no one does, so we can enter that testimony by stipulation. That's the testimony of Christopher Lowe.
Yes,
that
of
correct?
Christopher Lowe,
Okay.
yes.
Direct testimony of Christopher Lowe. Do you want to
So,
tell me about
yes,
it?
please. Staff asks that the direct testimony and exhibits of Christopher Lowe on behalf of the staff of the Public Service Commission of Maryland, pre-filed on December 20th, 2024, as mail log number 314447, consisting of 8 pages of written testimony and 1 exhibit, be marked as Staff Exhibit 1 and moved into the record by stipulation.
Okay. Staff Exhibit 1 will be moved into the record.
Your Honor, may I have one point of clarification? We talked about making 2 changes, I think. We were going to add the terms "and proposed mitigation" to the glare analysis condition, talking about 60 days out, that they would file an updated thing, and if there was problems, add "and proposed mitigation," and we were going to remove the term "material" from changes in the glare analysis.
Yeah, and you probably need to do something to make it clear, because this is the second time Mr. Seaman has told me that the materiality of the change is not the glare, but the stuff. So that probably needs to be reworded.
Okay, well,
And then,
I wanted to clarify that you wanted us to do that in our revised RLCs.
if you can, that'd be great.
Okay.
The record will be held open, not only to receive PPRP's revised conditions, but for other purposes. It'll be held open indefinitely. Does anyone have anything else?
No, Your Honor.
Your
Thank
Honor.
you.
Thank you.
Thank you.